What happens if you waive time in a criminal case? Hi, my name is Carl Birkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to help you make law easy by just talking a little bit about what happens if you waive the timing in your case. So, the short answer is there's not much that's going to happen. So if you're waiving time, it's usually, at least in my experience, you're waiving maybe you have to have if you're having an arraignment and you have to have a hearing past that arraignment within 20 days. A lot of times, like if I'm dealing with a post conviction probation violation case, those need to be heard within 20 days of your arraignment date. So if you violate the rules and conditions of your probation, the state files a motion to accelerate or an application to revoke your suspended sentence. You would show up, you're not guilty, and the court wants to litigate it relatively quickly. But you have the option to waive that time. Usually, I will do that because 9 times out of 10, I'm not saying every time, but 9 times out of 10, if we're dealing with a probation violation situation, man, that's a lot of shit. Anyway, if you're dealing with a probation violation situation, um, the court's going to be looking at, what did you do to violate the rules and conditions of your probation? And not, like I said, 9 times out of 10, my clients probably have violated their probation in some way. They'll have forgotten to pay their fines, or they'll have forgotten to pay the DA's office, or they'll have forgotten to take a class, or they will have missed a class that they were supposed to take. So, something innocuous and simple, but it's still a violation and therefore can end up getting them thrown in jail. But if I can waive that time, that gives me time to work with my client to get them back into compliance with the rules and conditions of their probation. Gives me time to get them back on a payment plan so that way they can be getting their fines, fees, and costs paid off. Get back in touch with their probation officer so they can get checked in and get their information updated. Get back in the classes that they're supposed to be taking or make up the classes that they missed. And if we do that, almost every time, the state will end up dismissing the motion and allow my clients to stay out on their originally, negotiated plea and probation. So waiving time in those instances isn't a bad thing. Now, that's not always going to be the case, and depending on the situation, definitely talk with your attorney about the pros and cons. But there's definitely some solid pros towards waiving depending on the situation. If you have questions about this, give me a call. I'm more than happy to chat about it with you. My name is Carl Birkhead. I'm with Worth Law Office, and I want to help you make law easy. Thank you.